Hello, everybody.
Hey, Bob, how are you?
Welcome to a webinar, and everybody. Okay. Prop 65, certainly not one of anybody's favorite subjects, but I actually got 3 totally different requests for information and help in Prop 65 in 3 days in a row earlier this month. So, I knew it was, again, a topic of interest and need for information for the members. So we were able to put this together. And the first thing that came to mind, first person to reach out to was our speaker today, and I'll introduce her very shortly. Just a couple of housekeeping kind of details for you first. During the presentation, as you are now, you're all be muted. If you're like me and may not remember your question, you can either write it in the chat box. You can post it to everybody, or you could do individually to me, and I can read the question in the Q&A. Or you could just simply wait until the end of the presentation, and we'll do a Q&A. And our speaker has been gracious enough to say that she's leaving plenty of time for questions because there always are quite a number when you deal with Prop 65. So I first met our speaker, Sophia Castilo, a year ago, January. We were both on a panel on import type related issues and current trends and issues. And I was quite impressed with how she was able to make Prop 65 sound a little more manageable and maybe not quite as burdensome and onerous as some others have. So we were fortunate enough to have her speak at our online convention earlier, a few months back. And she was the first one I reached out to as soon as the questions came in. So we are pleased again to have Sophia Castilo with us today. She's with DowneyBrand, and she's an environmental lawyer that helps folks like you comply with Prop 65. She's been an active Prop 65 defense attorney for many years. Her practice includes litigation, negotiation, building, and implementing compliance programs. She has a particular interest and passion for food. And she's worked with national brands, private labels, institutional suppliers, and retailers and the like. So, and she also has a 60-day notices of violation, like a regular update on Prop 65 that you can get on LinkedIn, for example, and I think JD Super is another. So with that, I will turn it over to Sophie. And Sophie, again, thank you so much for being with us today.
Hi, Bob. Hi, guys. It's so nice to be here. I've gotten to know, can you hear me?
We have to unmute you.
Okay. Can you hear me?
Let's see, you may need to unmute yourself. Bottom left. There we go. I can see.
I'm unmuted.
Not hearing you.
No. Angela says maybe she can hear me. Everyone else can. You can? Okay. It's nice to be here with all of you. And Bob has become a friend and colleague over the last year that we've all been locked in. We've been corresponding after we spoke together on our panel at a conference. And so it's really nice to have a chance to talk with you all here. And I've gotten to know some of you through Bob as well. So looks like I might be seeing some friends in the audience. I will, my thought was that I'd talk for about half an hour or so and then leave some time at the end for venting and commiserating and also brainstorming, because I've found that these sorts of things apply, Prop 65 in particular, applies differently to everyone. And oftentimes different organizations or different businesses have really creative and thoughtful ways of managing these issues that they want to bounce around. And when we all have a chance to talk together, we might come up with some great ideas. Am I clear to share my screen? I think I am. Okay, I'm gonna give this a try. I'll pull up my PowerPoint. Oh, hang on. I might need you all to give, okay, we're good. Try one more time. I think AFI might need to give me privileges.
Okay, give us just a second there.
Try one more time. There we go. Okay. So I will go ahead and go through my presentation. Be sure to keep your questions or just type them in the chat box. And we can all take some time afterwards to vent and brainstorm together about all these issues. So my thoughts this morning were that we would cover four main topics, and I think that the last two, particularly the last topic, might be the most interesting to all of you. I'll give a brief overview about what Prop 65 is, and you probably already know, but nevertheless, it's always good to hear it again. I'll talk a little bit about the common claims, the foods and the chemicals that we're seeing that apply to folks in your space. Then I'll give a brief overview about how you technically comply, and then we can conclude with a section that's really about creative management of your relationships with suppliers and retailers in particular, who are really getting targeted here, and some things that you can do to limit your claims. And that should segue nicely into an opportunity for all of us to chit chat. California's Prop 65 is a law that has been in place in California for a number of years, since the 1980s, that requires all products sold in the state, including food, to have a warning label. And that warning label is only required to be applied to the products if use, or in the case of food consumption of the products, causes an exposure to a chemical on the state's Prop 65 list above a certain safe harbor level. And one of the things that makes Prop 65 tricky is that the list contains 900 chemicals. But as you will find today, there's sort of a short list of favorites that these plaintiffs' attorneys like to target. And so those are the ones that I advise clients to focus on. And as you get more and deeper into this space, you'll find that there can be some emerging chemicals that that maybe you might hear about in a trade association or at a conference that are worth keeping your eye on. Here is the standard warning label for food, and it is not negotiable, and in some cases somewhat offensive, because it requires you to describe that your product may cause cancer, birth defects, or other reproductive harm. Interestingly, there is some proposed legislation that you all may be aware of. It got really robust public comments, hours and hours of public comments a few weeks ago, that would provide for a short form warning label on food that shortens this language a little bit. That proposed regulation has not gone into effect yet. So if it goes into effect, you might see some shorter language that you could use should you choose to warn. As you all know, or maybe foreseeing, Prop 65 can be really expensive. The law is powerful because it gives citizen plaintiffs, or these public interest groups, a right to sue industry or products sold in the state if they feel like any product that's sold doesn't have the warning label that it needs to have. And so because there is this, it's called a citizen suit provision, but because there is a provision allowing citizens and public interest groups to bring these claims, there's an accompanying provision that allows their attorneys to recover their fees for bringing the claims. So not only have citizen prosecutors been emboldened by the law, but their lawyers have as well. And so in this world, you know, there are a short list of plaintiffs' attorneys, and after a long enough time, you get to know most of them. And they're motivated to bring these claims because if the claims settle either in court or out of court, they get to collect their attorney's fees, and folks in your position as a potential defendant unfortunately have to pay those fees. And so because of that carrot in the law, we have seen that cases are continue to increase every year. Every month, there are roughly around 300, 320 notices. In some cases, they amend notices or claims that went out previously. And in most cases, they're new. So about 300 every month. I found that I'd say about maybe half of those relate to food products. The other half are consumer products. Plastics are really big. And products with metals in them that might contain lead. And so you might think, well, because the label is a get out of jail free card, the law doesn't require you to reformulate your products. You might just want to slap that label on and go home. The problem is labeling itself is expensive too. And with every new Prop 65 case and lobbying opportunity, without fail, the industry gets together in California and calculates how expensive compliance and labeling with Prop 65 can be. I took these set of statistics from some work an industry group in California did for the last big Prop 65 matter that it felt like it needed to comment on. And so this industry group actually did a cost study and calculated the expected costs of labeling over the next decade, which you can see are quite astronomical. The average settlement, I have heard this number thrown around, I think it might be higher, that may not be the case, is roughly $30,000. It depends on the plaintiff's attorney that's prosecuting you, and of course your sales volume. And as we talked about, unfortunately, the majority of Prop 65 settlements are these attorney's fees. Here is a great figure that came from a Los Angeles Times article last summer in the midst of COVID that was just fantastic and talked all about Prop 65. I'd be more than happy to send that to you if you want to read it. They took data, not to completely to present, but pretty close, and tallied up the industries that were being hit the hardest by Prop 65. And so you can see food and beverages are really out in front there. Lately, though, I would say there are a lot of plastic claims. So this might have flipped a little bit. You might see that that maybe some household products or some clothing accessories might be coming out a little bit more equal to the claims targeted at food and beverages because of those plastics in purses and bags and cases in particular. So in the food space, we see really a short list of chemicals that are targeted. Acrylamide has been a big one for a very long time. I'll talk about the foods that acrylamide is in shortly. There's a proposed regulation trying to give some certainty to acrylamide levels that are allowed. But acrylamide occurs when foods are roasted and browned and become crispy. The main things that you see acrylamide in particular are like crispy, crunchy snack foods that are browned, cookies, crackers, popcorns, pretzels, cooked tortillas, tostadas, things along those lines. Olives, also nuts, nut products. And then outside of the acrylamide claims, the majority of the claims really are for heavy metals. So lead, mercury, cadmium, and arsenic. The two that I see the most are lead and cadmium, and the one that really is the leader is lead. Okie doke. So when we're moving on to talk about the food groups that are targeted, really the short list is the list of the oldies but the goodies over the last, I'd say, year and a half, maybe 2 years. Our first item in this list is, I call it crispy brown snack foods. This is the acrylamide list. It ebbs and flows depending on the tastes of the plaintiff's attorneys of the month, but they have a real ability to go through food groups in a very organized and planned fashion. So for instance, 1 month you'll see tostadas, 1 month you'll see tortilla chips, then 1 month or 2 months it'll be the cookie month. And they are very, very, very strategic about the foods that they go through. What has been interesting about this year is that in addition to these acrylamide claims, we are seeing lots of claims for fruits and vegetables. And even some fresh vegetables, a number of dried fruits and vegetables, and canned fruits and vegetables. The allegations in those claims usually relate to metals in the fruits and vegetables. And for instance, in the case of fresh vegetables, the hypothesis is that the fruits and vegetables where they're grown uptake the metals that are in the soil or maybe in the irrigation water, and then themselves have a certain level of metals that are present, that are coming up in these tests that the plaintiffs are doing of the final product that's sold in the stores. Seaweed has been a long time target of the Prop 65 plaintiffs in various forms. Kelp and nori and all sorts of different seaweed that are sold in grocery stores in particular. Seafood too, that may ring a bell for all of you. There were the tuna mercury cases many years ago. Always quiet on the seafood front for a long time. And then during the COVID period, a huge batch of seafood notices went out alleging that packaged seafood, usually canned or sometimes sealed in plastic bags, and every type of seafood you frankly could imagine, shrimp, clams, mussels, anchovies, contained various levels of metals and needed a Prop 65 warning. Chocolate has been an oldie but a goodie that goes away and comes back and goes away and comes back. The main allegation there is that chocolate contains cadmium. And pretzels are interesting because they are checking the acrylamide box, and then they've also come up as a hot topic for a new chemical that seems to be gathering steam. It's called furon, and it has a lot of the same properties as acrylamide. We're still learning more about that and learning more about those claims, but every month we see a few claims for pretzels. So what's interesting about Prop 65 and how foods are targeted is that they're targeted largely at the retail level. And that's because the plaintiffs and the plaintiffs' attorneys have a very simple business model. They hire buyers to go out to certain grocery stores to buy food products that are in the categories that we talked about. They send them to a lab. They test the food products for the chemicals we talked about. They have an on-team engineer that calculates whether or not they think the level of the chemical is high enough to require a Prop 65 warning. And if it is, they initiate a claim. I have seen lately a number of private label products that have been targeted at certain retailers, but it's not always private label products, but it can be. And it oftentimes is private label products that are targeted. So if we shift into now a discussion of compliance, actual compliance with Prop 65 is incredibly technical and most definitely requires the input of a scientific consultant if you want to go down that road. And I talked a little bit about this when we all last spoke before. I'll describe this process to you a little bit, and then we can talk about some risk management strategies. So first and foremost, if you have a product that's been targeted by a Prop 65 plaintiff or you think might be targeted, you're going to want to test the product for the chemical you're worried about. In cases of lead, by way of example, it's often best to test a number of lots and a number of different products within the lot to get a sense of if the lead is concentrated or if it's consistent. I've heard from consultants that lead is one of those chemicals where sometimes you can have a hot spot for a variety of reasons, including things like how the products are packaged. Because Prop 65 doesn't exclusively regulate the level of the chemical in the food, it only regulates the exposure of consumers to the chemical. There is a consumption component to Prop 65 compliance. And so we have a safe harbor level in the law above which you need to put a warning label on your product. But to calculate that safe harbor level, consumption is essential because you can't determine how, for instance, can't determine how many California consumers would be exposed to alleged acrylamide in popcorn if you don't know how much of the popcorn they eat in the first place. And so one of the reasons why this exercise can become technical and complicated is because you have to look to some consumption data. And the accepted consumption data is difficult to harvest, and consultants specialized in gathering the data and then helping you with the calculations. as I alluded to, it can be hard to undertake an exercise like that for every single product you have. It would be cost prohibitive, and it would take a tremendous amount of time and energy and coordination. Strategies that I have seen successfully implemented include businesses monitoring Prop 65 claims for hot products or hot categories of products. For instance, if you sell sandwich cookies and you see that a certain plaintiff every month for the last few months has been targeting chocolate or vanilla sandwich cookies, they might be coming around to you next month if you do a tremendous amount of business in California. So that could be, for instance, something that you'd watch. And this becomes a task of managing your risk and deciding where you want to spend the money. If you do a huge volume of business in a category of product that's been targeted by these attorneys, it very well may be worth it to do some testing and get a sense of where you might fall on the spectrum and if you want to put some warning labels on. If most of your business is in different foods than are being targeted, it might not make sense to invest that level of time and effort and money now. So the best thing I think you can do to comply is to get educated about what the trends are. Follow the trends. I write a really short blurb every month that I'd be happy to send you about the trends. And if you think some of those trends are getting too close to home, dig a little deeper into what you're selling to see if you might want to put a warning label on or adjust some things to bring the levels of the chemicals down in your product if you think they're high enough for concern and to be concerned about. I talked about this a little bit, and I'll talk about it a little bit more. So a Prop 65 claim is implemented and initiated and started by first plaintiffs going out and testing foods that they find just at grocers or big box stores, and testing foods that contain a list of contain chemicals, probably most likely on our short list, maybe with a few emerging chemicals like I talked about that kind of percolate around the edges to see if they can gather steam. Plaintiffs are only going to test your products if they don't have warning labels, because if you have a warning label on it, you have complied with Prop 65, you're not going to get sued. It's a get out of jail free card. You are done. So you only become a target if you don't have that label. If your foods contain the chemicals at a level that plaintiff thinks is high enough to require a warning label, they will send a 60-day notice of intent to sue. And companies respond in a number of ways. They may negotiate settlement. They may push back and say, I've done extensive studying and testing of my products, and actually they don't require a Prop 65 warning label, and here's why. When we segue into this issue of managing relationships in the Prop 65 world, certain things I think become pretty established and are non-negotiable. Retailers, for the most part, require, as a matter of course, certifications from their suppliers that they're complying with Prop 65, and almost always inquire identification and defense of any Prop 65 claims that occur from their suppliers and from folks that are up the supply chain. And so what you see happen is that the liability for these claims is going to flow up the supply chain, and it might stop at the top with the importers. Usually, sometimes there's an interim entity that's a distributor or helps to connect suppliers or importers to their customers. That entity will usually shift the liability up and tender it up as well. I have yet to see a foreign company indemnify any American company for Prop 65 claims. It is not clear to me that that's common or it happens all that much. But what I am hearing is that foreign companies are getting enough asks about Prop 65 that they're starting to test their products for the common chemicals like lead, and some other metals, maybe acrylamide. And so this becomes an issue of your business relationship and what can you do if you have foreign suppliers to work with them to figure out how to comply so that no one is holding this liability in the supply chain. My high-level thoughts on what to do next are this. Require testing of some common Prop 65 products from your foreign suppliers. heavy metals, lead, cadmium, acrylamide are good ones if you think that you have foods that are being targeted by some of these Prop 65 plaintiffs. If you think you are particularly at risk, you would be well served to conduct some spot testing yourself to see if any of the products that you sell in California might have high levels of metals or acrylamide. And you might consider a warning label. If you're not opposed to the label as a matter of course, if your retailers or your customers aren't opposed to it either, that's a way to completely foreclose the claims and comply with the law. And if a warning label isn't sitting well with you or isn't sitting well with your customers, it's definitely worth considering a deeper dive on a consumption analysis if you have levels of chemicals in your product that are close. That is, well, you know, I have a little bit of X chemical in my product. I think it might be okay, but I'm not sure. And I really don't want to put that warning label on my product. That might be a time to work with a consultant, work with a lawyer, and do some strategizing about how you can justify not having a label on the product if you're targeted, or think a little bit more about if it would be worthwhile to have that label on to come into full compliance. In conclusion, I think that there is competitive advantage in California if you have a Prop 65 strategy. And Prop 65 strategy for every business is different because every business is different. And that strategy is largely dictated by the amount of sales volume that you have in California and what products you're selling a lot of in California. And if you have products that you're selling a lot of in California that are being targeted by these Prop 65 plaintiffs, it's probably just a matter of time until they come around to you or come around to some of the retailers that you're doing business with. Retailers are absolutely requiring Prop 65 compliance, and in their minds, it's interesting because some of them may actively monitor that compliance. You know, show me your test results, fill out the certification, sign and attest that you have conducted a Prop 65 compliance program for this product. Others may say, I really don't care what you do, but if I get sued, I'm sending this lawsuit to you. So there are various ways that retailers deal with it. The commonality is that they're just going to send these lawsuits up the supply chain. And the key strategy here, and then this is certainly a good stopping point for us to brainstorm and chit chat a little bit more, is that to understand your risk, you have to understand your products and what you're selling in California. You can test and warn as necessary and according to your preference, and certainly have a plan if you receive a claim. And by a plan, I mean, well, we know that this product might come around. We've done a consumption analysis. We've done some testing. The numbers are close, but we feel pretty strongly that we don't have to warn. And here's our analysis as to why. You can keep that in your file. And if you need to pull it out later, it's certainly a good thing to have. And thank you. It's been nice chatting with you, or at least talking at you. And I see a number of things that have come up in the chat box. So maybe it's a good time for all of us to open up the mics and see what we have to say.
All right, so while we wait for folks to unmute and start asking questions, I'll read a couple from the chat box.
Okay.
If I have doubts that a certain chemical could impact Prop 65 compliance, but I'm not sure, would you recommend put the warning label on the product as a precaution?
I think it depends. I mean, it depends on your preference and your marketing strategy and the preference of your retailers. Some retailers, frankly, don't care. Others really do care. And that probably is a function of their business. If you put the label on, you will not get sued and you will not get a claim. And in those cases where it's a close call, it really comes down to how much money do you want to spend on this issue and what are the preferences of folks at your company and your customers. So if you put the label on, you're done. You're not going to get sued, but maybe people in your sphere have strong feelings about the label, and they can, but not always.
Mhm. And then what if the only products we sell in California are online? So Walmart, Amazon, et cetera.
Online places like Amazon and Walmart and Target are huge favorites of the plaintiffs' attorneys. And when no one was leaving during COVID, when everyone was locked inside in California, because the situation in California really was pretty dire, we saw those claims go through the roof. And it's funny. I mean, they're doing everything from ordering on Instacart and to buying products on Amazon, to buying products on Walmart.com and Target.com. So usually the big online retailers will require a Prop 65 compliance statement from you. I know that Amazon and Target in particular, when you're onboarding with them, they make you check a box or elect to put that warning online. So they would usually talk you through that process if you're working with them.
Okay, and then an interesting concept. Do you think any other states may join California, require similar labeling?
I heard, I get asked that question a lot. I heard many years ago that Vermont was considering it. And I don't know if that ended up happening, but I have heard crickets on that topic since. I mean, this is really a weird one. It is just a weird regulation. And, people in Europe are sort of appalled by it, because in Europe, there's a tremendous amount of time and energy and research devoted to regulating toxic chemicals. And nothing in Europe rises to this level. So when I have worked with overseas clients, they're absolutely astounded.
As a company with under 10 employees, we have a safe harbor, correct? And then why isn't the threshold for what is deemed safe aligned with federal regulations?
I mean, and that's a good question. I think it's probably been a source of a lot of lobbying and argument by trade groups and industry over the years. It absolutely should be. And you are safe if you have under 10 employees. There are a few things to consider that come up in my practice from time to time on that issue. Mostly that even if you have less than 10 employees, you may have contracts with your customers that require you to step in and indemnify and defend these cases regardless. And so, for instance, Amazon, I don't do any work with them, so I can talk about them. They have a pretty stringent policy where if one of your products that you sell on their website is the target of one of these lawsuits, you're obligated to pay the costs of that defense in resolving the claim. So it'd be nice to be able to get out of jail free if you had less than 10 employees. Sometimes it's difficult based on your contracts and your business arrangements to do that.
I guess question kind of gets into how to stay current on what's going on. So the way it was phrased is, where can they check the hot products under Prop 65 filings and activity?
Yeah, so it is hard, but not impossible. I every month do a very high level overview. I'd be happy to send to all of you, or Bob could forward it around when it comes out. I can put you on our email list. There is, if you're interested in this topic and you want to spend the time, there is a portal of claims that the Attorney General maintains, and it's public. So you can go to the Attorney General's website, you Google Prop 65 60-day notice search, and it brings you up to a public database. I think they call it the Prop 65 web portal or something similar. And you can search for your name, your competitors' names, and you can search for claims by month. So if you wanted to pull up a huge spreadsheet of all of the claims over the last year, you could do that. You can enter food types, you can enter company names, you can enter chemicals.
Yeah, interesting. This one's specific, and you may not know the answer if you haven't looked at California domestically produced olives. Do you happen to know if they're using the warning label?
I think it probably depends on the company.
All right.
It probably depends on and who they're selling it to, and is it private label, and do they want the label, and and all of those questions. This issue of acrylamide, because olives can have acrylamide in them, the issue of acrylamide is tremendously frustrating because the state has a very, very, very low safe harbor level above which you're required to put that label on, and olives can contain acrylamide. There's been a lot of lobbying done to raise that level. It's a lot lower than the European level, significantly lower by way of example. And so the reason why, because the level is so low, these plaintiffs' attorneys go absolutely bonkers for Prop 65 claims. I think that the state is starting to recognize that, and it has a proposed regulation that would actually give levels of acrylamide in different products like cookies and crackers, so you know for sure if you have to warn or not. And so we're hoping maybe, some things like that will pick up steam, but that's a frustrating one. It really is.
Okay, I think that relates to one of the other questions. I'm assuming the acrylamide proposal that you're referring to is probably one that came out last summer or so, because that's what somebody was looking to get an update and what changes it would be.
Yeah, I think it did come out about last summer.
Okay.
It hasn't gone into effect yet, and it provides a short list of foods with the actual acrylamide level next to the food. So for instance, I think sandwich cookies is on the list. And so you'd go over and say, well, if I have a sandwich cookie that has this much acrylamide in it, I would have to warn. And that's the proposal. People like that in theory, because at least and you don't have to do this extensive consumption analysis. But the question remains if the levels are actually realistic.
Right. And on some mechanics here, warning label is currently only in a long form, correct? What does a short form mean, and when can it be used?
So this is another topic of legislation, and I will say at least we know that the California legislators and agencies that are in charge of Prop 65 are not asleep at the switch, because when the new warning regulations came out in 2018, they became tailored for different industries. And I showed you the long form food warning, and it was not clear if a short form warning was allowed on foods. And the Attorney General's office and the legislature and the legislators got tons and tons of questions about, can I use a short form warning on foods? And no one knew the answer. So now there is a proposed short form warning for foods, but predictably, the language is completely different. No one liked it. And I think it was a week and a half ago, they took public comment on this topic, and every industry group under the sun was going on for hours and hours and hours about how folks didn't like the short form warning. So at the moment, I would say you use the long form warning, and we wait to see what happens with that.
All right, great. We have a couple questions related to food service. So is it needed, or if not, would they be safe including something like this product is not meant for retail sale? Would that cover them?
Oh, that's interesting. That's an interesting idea. I haven't heard that. And that's a funny question, and it's a question I do get from time to time. I think the truth is that these plaintiffs are targeting products at a retail level in online or in brick and mortar grocers or big box stores. I mean, that's just what's happening. So from a risk perspective, if you're selling in bulk to restaurants and things like that, you may not immediately be targeted by a plaintiff. But as a matter of caution and good business practice, I do see upstream sellers putting the Prop 65 warning on their product just as a precautionary measure. And so there are a number of ways you can do that. You can sticker the product. And then there's a downstream notice procedure where you give your folks downstream the warning with a letter describing what you're doing. I've seen circumstances where upstream folks in the food world will provide some sort of a letter along the lines of, whether or not you need the warning depends on consumption. We don't know how you're going to use what we're giving you, but you might want to think about this.
Mm-hmm. All right. In terms of the size of the warnings, labels, and fonts, that information is on the on the state's site, I assume, or?
Yeah, it is. And I think that there isn't a font warning unless it's short form, and short form is up in the air as to whether it applies for foods. But the food warning is a little different because it requires a black box around it. And then it doesn't have an exclamation point like you might see for plastic purses and things like that. For cars, like I was driving down my kids to school this morning and I saw a Prop 65 warning on a car door next to me. I mean, they're just everywhere. They're everywhere.
Yeah.
Yeah.
Okay, are Prop 65 testing methods and procedures available prior to judgment? In past experience, brands involved in legal action were not advised of official testing methods until settlement. How do we know if we're testing at labs with certified procedures and methodology?
I would say if you are to the point in your procedure where you're testing, it would be worthwhile to buy a few hours with a reputable consultant to give you some guidance on that. If you do some research on the labs, usually you will be able to figure out if it's a real lab and it has adequate certifications. But again, only a professional in the space could probably give you the exact type of testing method that you need and a list of good labs. Out here in California, there's one lab in particular we use because I'm in Northern California and it's in Northern California and they support a lot of Prop 65 defense. But there are other labs that come up from time to time that people use. And I actually have noticed one lab being used by both plaintiffs and industry side. So it takes a little bit of education and be worth, getting some input, I think, from someone that works in the field. I would say a technical consultant. If you're to that level where it's that important, then you're pretty far ahead of the game.
All right. Can a company receive multiple lawsuits for the same Prop 65 chemical?
It could be for the same chemical, but probably not for the same product. And it depends how the product is defined, and it depends if you have any prior settlements. But the same chemical, yes. I mean, if you only sold one food product in the entire state of California and you received multiple claims for the same chemical from different enforcers, that probably wouldn't fly. And I've often suspected that they actually coordinate because we don't see that happen very often. But you could receive multiple claims for the same chemical for different products.
All right. You probably covered this a little bit already. Is there any one general specific warning label that will cover all products since we have many ingredients for just one product?
And ingredients. I think the warning labels are targeted at the chemicals.
Right.
So and again, because food is kind of yet to be determined with the short form warning, the language, if you were concerned about the same chemicals in all of the products, you could use the same label. It just depends on which chemicals you're worried about. So if it was always lead, you could pop the lead into the sample template, make sure you get the right language, and use it on all of your products if the concern was lead. But if it was lead and mercury for some or lead and cadmium for others, you'd have to do some mixing and matching.
Okay, my company produces canned seafood. We sell to different customers under their own label. We're indicating in our invoices that the product does not comply with this Prop 65. But if by any chance our product is sold in California and a claim is issued, who would be the responsible party?
Probably depends on your agreements and whatever business arrangements you've made with any distributors or retailers downstream.
Right.
In some cases you could be, but again, it depends on your business relationships and your agreements. I would take a look at those and see.
All right. Some of the next ones are kind of more philosophical.
We could really get into it, I'm sure.
Yeah, any quick thoughts on whether people actually read the labels or if it deters their, I mean, you saw it on the car door this morning. So, I mean, it's all over the place on everything.
we see it everywhere. And I don't know if any of you are in the coffee business or followed that saga for years and years. I mean, the coffee industry, what it has been through on this issue, but it really banded together and it fought. And so that as an industry, and apparently from my understanding, I didn't do work on those cases, every coffee distributor, seller, retailer in the state of California participated in that effort to push back. And ultimately, there was a carve out in the law that applies to coffee, but it took a long time for them to get there. I say that because before that carve out happened, there were warnings at Starbucks. Every Starbucks that you walked into had a warning up, and people were still buying Starbucks. The warnings are not up now because they got that carve out in the law after such substantial effort. But you know, I have seen them at drive-throughs, Burger King for acrylamide. I think Burger King got sued a really long time ago. It was one of the first ones for the French fries. I mean, the warnings really are everywhere. The other interesting thing about it is that you also have to have a warning for alcohol. And I haven't talked about alcoholic beverages because it's kind of a different world. But you do have to have that warning up for alcoholic beverages, like at a bar, and it doesn't stop people from going to a bar. I'll tell you that. Well, I mean, now maybe not, but although I think everyone's itching to get out. So.
And then a related question, acrylamide may or may not be able to know the answer to this one, but basically, are you aware of any other countries doing anything similar to what the EU did in terms of the setting the acrylamide levels?
Yeah, I mean, my understanding about the EU is that the acrylamide levels in the EU were considered to be very conservative and protective, and that our level here in California is much, much, much more conservative than that of the EU. I don't, beyond that, I don't know much about foreign regulation of acrylamide, other than more conservative than the EU.
Mm-hmm. Okay. And one just came in. Let me see, would you please, I guess, an update on the lawsuit, lead and balsamic vinegar? You aware of what's happening in that one?
Yeah, you know, I know that there were a number of settlements and there was a lot of activity on this issue many, many years ago. And then a round of notices went out on lead and balsamic vinegar during the COVID period when everyone was at home last summer. And the general thought was that some of the folks implicated in those notices already had settlements that would preclude that second round of claims. But I mean, beyond that, I can't give any specificity. The lead and balsamic vinegar has been an issue that's floating around out there for a long time.
Yes, it has. Yeah.
But I also think many folks have settled those claims. So because it's an older issue, usually if an issue is around for a long time, there are some settlements out there that might govern. So if it's something that applies to you and you don't have a settlement, someone you work with or someone you buy from or someone you distribute for or do business with might have a settlement that helps you.
And just a quick kind of note, as Sophia mentioned, she has the routine update on Prop 65 issues, and there's always news about it. Right now, there was legislation introduced. I haven't had a chance to look at it all yet. I'm going to reach out to somebody who's asking AFI to support it, and we'll update members when we find out on that. But it is something, because it's impacting so many products, there's always something going on with Prop 65. So I definitely recommend that you, if you're selling product in California, or it may end up in California through Amazon or some other vehicle, that you definitely pay attention to what's going on out there through resources such as Sophia or anybody else that you can reach out to. Couple more just came in. I think, is Prop 65 planning on accepting higher levels of acrylamide in food? I think that was sort of addressed earlier.
Yeah, I mean, no gets that level, that is a very, very, the published level above which you have to warn is very, very low. And there's an alternative level that's floating around out there, and industry is advocating for a number of things. So that's a real source of heartburn out here. It really is, and I hope it changes. It's very low.
Right. Then an interesting one just came into, so basically, yeah, I'll kind of paraphrase it. You know, the product really doesn't need a warning label, but you put it on anyway. Is there any, is that permitted, or is there anything wrong with that?
Here's my long answer. There's a conference every year. It's the Prop 65 conference. Businesses can come, and I hope that, again, things get better this summer, because it's kind of a neat thing. It's the Attorney General's office, the regulators, businesses, plaintiffs' attorneys, and defense attorneys all go to this conference every year, and it's at a really neat old building in downtown San Francisco. And it's a old school, nice lunch. Everyone sits around and has a nice time together. I mentioned that because every year at the conference, this issue comes up, and the Attorney General says the same thing, which is, we don't like claims for overwarning, right? Which is slapping that label on when you don't need it. Now, I'll say I have never seen the Attorney General come back and get mad at someone for overwarning. But theoretically, I think that they could, if they felt like you were overwarning, ask you for information supporting why you're warning. Now, it seems to me that they have their hands full, and that's a pretty kind of far out proposition, but I think theoretically it could happen. So it sort of depends on, again, what your preference is and what your risk tolerance is. I mean, if you have a fair amount of a chemical in your product that really might expose you to liability, people often will put the warning label on. Now, whether or not it's absolutely technically correct down to the last little detail, I don't know. Sometimes that ends up being a business decision more than a scientific decision.
The question that just came in, it's actually less a Prop 65 question, I believe, than a food safety issue. So is it mandatory to try to mitigate acrylamide levels in your product? Well, yes, it would be in the Food Safety Modernization Act, because acrylamide's a known or foreseeable risk in your food, and you're supposed to do whatever you can and be able to prove you've done it. I don't think Prop 65 would really go anything above that, because if acrylamide is on the list and it's in there, then that's one window, and then the other window is food safety.
Yeah, and I think that there's some older FDA guidance on how to reduce acrylamide levels. Have you seen that or worked with that at all, Bob? I think it's floating around out there.
I think you're right. Yeah, it's been a while since I looked at that one. Yeah.
I think you can Google that, though, if you're curious, and it gives some suggestions about cooking methods and different things you can use to try to reduce that level.
So I love that you included the phrase venting in your lead into this section, and there's some venting going on here. So since lead, cadmium, mercury, and arsenic are naturally occurring in the Earth's crust, everything that grows in the soil may contain certain levels of these heavy metals. So we can as well just put a warning label on all fruits and veggies, right?
Right. Well, I mean, that's the argument. And so there's this naturally occurring exemption in the law. What's unfortunate about the law is that it means that you'd have to pay an attorney to fight to prove that point. And so you can't just assert this is naturally occurring, therefore I'm not putting a warning label on my product. And the law does shift the burden to you to do that technical workup to prove it. But I couldn't agree with you more. And whenever this issue comes up with my colleagues, I have a lot of colleagues that work solely in the ag space. That's the first thing they say. They say, how on earth could you be alleging that fruits and vegetables don't comply with Prop 65, because all of these chemicals are naturally occurring? It's a really interesting issue. I think that that's one that might get legs from a policy perspective, and we might see some things develop on that. The rice industry has a carve out for arsenic in the law. And I think that took a lot of effort to get that.
Okay. So we got time for a couple more. I think we have one here. If you test 10 lots have a product for lead and 9 of them have acceptable levels under the safe harbor levels, and 1 lot is over the limit, what would you recommend as the next best step to take?
Well, we have, if you all have the desire, there's a seminal case on this issue. It's called the beech nut case. It's the baby food cases a number of years ago, and you might have heard about those. Those are the cases that got into averaging of the lots and talked about how you find consumption data and what the acceptable consumption data is for foods. And the beech nut cases say, and they were affirmed on appeal, that you can average the lots. So when I work with consultants will, I've never seen them not average. And then if you in particular had one, and again, like I said, I've heard also from technical consultants that lead is something that you can have a hot spot or just for various and sundry reasons relating to who knows what, management, housekeeping, the facility, the water, I mean, the pipes in the facility, the list goes on and on and on. So you might look a little bit more at that lot and see why that is. I'm sure Bob has ideas too.
All right. No, yeah, right in line with what you were just saying there. So, and then one last one that came in, I'd like to know if there's quantity parameters to assess whether the items should be declared on a list and where she can find that. So.
The quantity parameters in terms of the amount of the chemical is what I'm guessing.
Yeah, I think that's what she's getting at. Yeah.
So this is, it's not an easy answer, but there is an answer. So the Prop 65 list has what are called safe harbor levels. And so those are the levels above which you need to put the warning label on. But much to the frustration of industry, those levels do not say if your lead levels are 20 parts per billion in, I don't know, insert random food here, you need to put the warning label on. Instead, they require you to consider exposure. And in the case of Prop 65, that means consumption. And so you're in a circumstance where you are going to need to consider consumption data in light of your lead levels. If you have a product that no one really likes and no one really eats a lot of, then maybe your lead levels could be very high and you might have a real reason not to put the warning label on. I don't know. I mean, what could be a totally bizarre product that has a lot of lead, but that no one eats a lot of, right? But vice versa, if you have a product that people eat a lot of, but the lead levels are sort of moderate, well, that's a situation where you might need to think about putting the label on. And so to do that calculation, you actually have to pull data. It's called consumption data and Haines data collected by the CDC, and it's a rather complicated exercise. But it's one of those circumstances where if you spend a little bit of time chatting with a consultant, you could probably come up with some screening values and figure out what the numbers are when you get into kind of a danger zone. I'm sorry that there isn't an easier answer to that. It's frustrating.
It is, and it's like, it's an average, folks. You got to keep that in mind too, because for example, if cauliflower had a lot of lead, wouldn't impact me at all. But average consumer, that's what your data has to take into consideration. So unfortunately, there really are no easy answers with a lot of government regulation, but including and specifically Prop 65. So some of you have posted in the chat some of the links and stuff to the OEHHA, which is the government entity in the state that regulates it. So it's definitely a website to become familiar with. I find it not intimidating, but you really have to have a clear mind when you go in to read it, because it's government speak, and it might list a chemical, but you may not be aware of whether it's in your product or not. So you have to do a little more research to see, okay, this chemical, is it known to be associated with my food? So it takes a little bit of homework no matter what it is that you're looking at with Prop 65. So, well, I'll turn it back over to you real quickly, Sophie, if you have any closing kind of comments, and then
Excuse me, Bob.
Yes.
Can you hear me? This is Masood. I couldn't put the question in chat. It was just a couple of general questions. First of all, Sophia, thanks for your presentation. Really appreciate it. Would generally the insurance cover this, the recall insurance or liability insurance, or that's going to go through those?
I've seen a lot of folks tender, and I've never seen an insurance company pick up one of these claims, but that's not to say it's impossible. I mean, if anyone has insurance contacts, they should create an insurance product for these claims, because I'm sure people would buy it. But I have never seen insurance kick in, unfortunately.
And if a company is no longer in business and a case brought up, let's say for a product that was sold a year ago, more than a year ago, what would happen then?
I would look to your business contracts, because I think that they would give you some guidance on that. This ends up being an issue of where the liability is flowing and who's going to end up with it. And usually your contracts with the folks that you're doing business with will describe that.
And would that be, I mean, if the company is already closed and dissolved, would that be coming against its owner or something? Or?
I mean, theoretically, again, I would think that you're some clarity on that. It's probably not a Prop 65 question as much as it is a general corporate and distribution and liability question. Probably the first place you'd look is to your contracts.
I appreciate it. Thank you.
In that kind of situation, is it likely so they've sent somebody out to the supermarket to buy the product, they find a high level, they find out now that this company's out of business. Is it worth their time still to go after it? Because it's likely only a little bit of that product left in circulation, right? So they might just move on.
I've seen a few of those where they will go into a hardware store. This is not food, and find the oldest piece of, nuts and bolts from 1975 in the back corner of the store, and the store doesn't even have a record of even buying it anymore. So there's some of those, and there's some cases where folks go out of business, and sometimes the plaintiffs may go away because it's not worth their time. I think there's an element of that.
Right.
Yeah.
All right. Any closing thoughts for us, Sophia?
Well, it's been chatting with all of you, and I know a few of you. I'd love to get to know more of you, and I'd be happy to send you our monthly update as well. And Bob can share my email, or I can put you on our email list. You can find me on LinkedIn, and I wish all of you the best of luck. You can call me to vent anytime, and I'm sure you can call Bob too.
Absolutely. And Sophia, we really appreciate your time and your expertise again, and your willingness to help us all. And so thank you again. And thank you to everybody who joined us today, and those who are listening on the on-demand portion, those who registered and couldn't make it live. So we look forward to seeing everybody in person soon. And in the meantime, stay happy and healthy.
Take care, everyone.
Thank you, everyone.
Thank you. Bye.